first case to come before the court today is in re LCZG, and ZG. Counsel for father has waived. Counsel for mother, Mr. Agarwal, I know you are already at the podium. Each party will have 15 minutes to present their arguments. Mr. Agarwal, let me know if you want to reserve time for rebuttal before you get started and how much time. The arguments are being recorded. Please keep your voices up, remain behind the podium. I know you're both aware not to use the names of any of the children here. Just refer to them as child, children, son, daughter, initials. The judges have read the briefs and we are ready to proceed when you are. How much time is everybody?
5 minutes, Your Honor.
All righty. Whenever you're
Now, may it please the court, Attorney Neil Agarwal for the mother in this case. Your Honor, I'll get right into my first assignment of error. When the agency filed its second motion for permanent custody on June 12, 2018, and as you read it, they only cite, under the first prong, one statute, 2151-414B1A. That is the should not, cannot subsection of the permanent custody. The judge, when she issued her ruling granting permanent custody, did not find that ground. The ground the judge did find was 12 of 22, and that there were 3 prior adjudications of abuse, dependency, and/or neglect. Neither of those 2 grounds were alleged in the agency's complaint for permanent custody. So I'm saying right off the bat, this court has held on multiple times, you cannot grant permanent custody unless it's raised in a timely manner, in a motion for permanent custody, and then we have a hearing on it. Going to my second assignment of error, the 12 of 22. Both the agency and the guardian in their motions specifically say 12 of 20, we are not seeking permanent custody under 12 of 22. However, that's what the judge found. On appeal, the state is not saying that's reversible error. They're saying, we don't have a problem with that, but I'm citing under page 2, my second assignment of error, on page 12, the timeline of how the agency has failed to get 12 out of 22. In fact, by my calculations, these children have only been in the agency's temporary custody for permanent custody purposes 6 months. The reason is there was an earlier permanent custody motion that was granted, and this court had reversed based upon defective service, where mom was in Jamaica jail, and the agency knew that, and yet they served her in Akron, and this court held you can't do that. When you know mom is in Jamaica jail, you don't serve her at Akron. So they reversed the PC, it came back, and then the agency, within a few months, again filed their second motion for permanent custody. So you take the time from the original removal to the time of the first permanent custody motion, that is about 2 months. And then after this court reversed the permanent custody to the time the agency filed the second permanent custody motion, it was only 4 months later. So I'm saying you take the first 2 months, you take the 4 months, the second time around, you don't have 12 of 22. You only have 6 months out of 12 of 22 purposes calculation. Now, when you read the state's brief, they don't really dispute this. They don't put any analysis. They don't say where I'm messing up the timeline. They just pretty much ignore this as an assignment of error. So I asked the court to find that they have not proven 12 out of 22. Now, the third assignment of error, I think, is a very interesting assignment of error. The judge, first of all, again, the agency did not allege permanent custody be granted because of 3 prior adjudications. However, the statute that we're talking about, 2151-414E, only came into effect in October of 2014. So what I'm trying to argue is that it is improper for a trial court to use that statute for adjudications that occurred before that statute went into effect. First of all, when you look at the statute itself,
had any of the children been adjudicated 3 times after the effective date of the statute?
all the children had adjudications before that effective date and after that.
Right, and had any of the children had 3 adjudications after that?
Yes.
Okay.
In fact, all of them but one.
Okay.
And my assignment here specifically only relates to one child.
Okay.
One child, for this purposes, had 2 adjudications subsequent to the enactment of that statute and had 1 prior. So I am saying, when you read the statute, first of all. In order to apply retroactive, you have to first look at the statute itself. Does it apply? When you read it, does it say this will be applied to all prior cases or from this date or whatever? The statute is silent.
But even if it's not retroactive, since the date of the inception of the new statute, revision, at least one of those children had been adjudicated to been neglected or abused 3 times.
All of them but one.
Okay.
I'm sorry if I
At
said
least
that.
one child of this parent has been adjudicated.
Yes, yes. From October of 2014 up until this permanent custody, all of the children but one have had 3 prior adjudications.
Okay.
And I guess I'm not disputing this ground for those children.
Okay.
But one child in particular has not. So I'm saying when you look at the statute, does it say on its plain face, does it apply retroactively? It does not.
Does it need to?
Yes.
If the other, I guess what I'm asking you is why are you contending that the court applied it retroactively if the other, all children but one were adjudicated at least 3 times since the implementation of the statute?
It would apply.
The statute doesn't require that child have been adjudicated 3 times, does it? Doesn't it say that child or any child of the parent?
Yes, but the judge did not make that finding either.
Okay.
The judge says, and when you read the permanent custody decision, this child, I'm granting permanent custody because this child has had 3 prior abuse, offense, and neglect cases. She didn't say based upon the siblings or others. So her finding is specifically to this child having 3 priors. 2 of them occurred after the enactment of this date, which again, I don't have a problem with. My sole issue is she cannot use prior to the enactment of the date, and it became effective, September 17th, 2014. So the reason why it's improper is prior to the enactment of that statute, if the agency says, hey, look, we'll do a dependency, we'll drop neglect, will you agree, and all parties say fine, in no way did that parent know, hey, in the future, this will count as one of 3, I guess 3 strikes you can say, for future permanent custody, because that wasn't even on the table. It wasn't existed. Nobody had any inclination or knowledge.
But
So,
I guess one, as a follow-up to the other judge's questions in regard to this, how is this not harmless error, if it is error at all?
I'm sorry.
Well, because you just said all these other kids have all been adjudicated at least 3 times after the enactment of the statute. You know, the court, if the court made that finding, which I'm sure it did, I don't remember that going through everything in particular. But the point is, how does that prejudice your claim here?
Well, first of all, the judge made a finding that's not supported in the statute. She says this child has 3 priors, which in itself is accurate. I mean, for what it's worth. The child has 3, but again, how many of them are applicable to the finding of permanent custody under this ground? And again, going back to my first assignment, this ground wasn't even alleged by the agency's motion for permanent custody. But aside from that, why can it not be applied retro? Because it's a substantive change. It is telling parents that these adjudications that you had no idea could be used against you will now be used against you for finding of permanent custody. Remember, this is a death penalty case, and the Supreme Court has held parents are entitled to every procedural and substantive due process protection permitted under the law. And then, so I'm arguing when you read it, you cannot find that this statute, assuming that you find that it's proper for this court to look at, one of those children cannot be found as having 3 priors. Now, lastly, to my last assignment of error. At the time this complaint was filed, there was an adjudication, and then the agency filed a proposed case plan, and then there was a disposition hearing. However, at no point did the court ever adopt or hold that the case plan that the agency proposed will be binding on the agency or the parents or anyone else. During the permanent custody hearing, mom's attorney, for unknown reasons just did not raise that assignment of error at any point. I'm arguing as my assignment of error that the mother's attorney committed ineffective assistance and had an affirmative duty to say to the trial court, look, Your Honor, my client is not obligated to do this court was supposed to adopt a case plan, assuming they wanted her to do services, but it didn't. At no point was mom had to do anything, no point did the agency have to do anything. Now, I did raise this assignment of an error in a prior case, claiming plain error, and this court held that it didn't, while it wasn't harmless error, it wasn't reversible error, it didn't rise to the level of plain error, so we're not going to reverse this exact same issue. So knowing that case, I'm not claiming plain error, but I am claiming ineffective assistance. The attorney should have raised, when they tried to introduce mom's medical records, mom's counseling records, mom's compliance on the case plan, at every point he should have objected, saying, look, she didn't have to do anything. Show me the journal entry that adopts a case plan. There is none. And again, he did not, and I'm saying that should have raised the level of prejudice.
You're right.
Yes, I was just going to say, I'll reserve the balance of my time. Thank you, Your Honor.
Good morning, may it please the court, Kevin DiMartino, guest on behalf of the Summit County Children's Services. The appellee, we are asking that this court affirm the permanent custody decision regarding these children. With regard to the second assignment of error, actually the second argument that counsel is making, which would be mother's fourth assignment of error, with regard to the case plan. So this case clearly had some procedural twists and turns. It did not go the normal route, I think that's safe to say. When this case originally had the adjudication and the disposition, there was a combined journal entry that was issued in this case on October 24, 2016, which discusses that there was a case plan. Mother was absent at that time. She had been kind of missing since about August of 2016. And there's clearly a discussion about a case plan and a discussion about grandmother wanting reunification, and the parties agreed to add case plan services for the grandmother as follows, reflected in record 34 and 34A, which discusses the things that were going to be added to the case plan for grandmother to do. So it does not appear, once the record was supplemented with the record from the case prior to the permanent custody hearing, it does not look like that case plan was ever adopted. Once that was added, I went back through everything, and I do not see a journal entry specifically adopting the case plan, but there is clearly a reflection of a discussion of the case plan, and then that case plan, after this case was remanded, was amended 5 additional times. So there clearly was discussions in court regarding the case plan, discussions with the caseworker regarding the obligations for everyone. So there can't be an argument that would be valid to say that mother was not receiving services or that the agency was not engaging in reasonable efforts. This argument that counsel is ineffective for failing to raise this issue doesn't make sense in light of the fact, bless you, that mother had filed for legal custody on September 4th, 2018. So she would have to introduce those same documents to be able to prove her motion. So counsel could not be deemed now to be ineffective for failing to object when the agency tried to introduce the very things that mother was saying she was doing that would help her be able to obtain custody of these children. So for that reason, and for the findings that were set forth in NRASC, the fact that there is not a legally binding case plan does not result in per se plain error and does not result in per se prejudice, and in this case did not. This case involved a mother who was missing for a long period of time, was arrested in another country. Once she was released, visitation had to be suspended at one point, multiple attempts to help mother. However, she was on felony probation. She had a violation right before the second permanent custody hearing for testing positive for cocaine in April and May of 2019. So she still had significant issues that were resulting in her not being able to comply with her case plan. But even if there wasn't a case plan in place, without even looking at the case plan objectives, there was also findings that she lacked stable housing, and she clearly was not in a position where she was sober and able to take care of her children. So there cannot be a finding of prejudice or ineffective assistance of counsel for the court's failure to adopt the case plan and the amendments to the case plan, of which there were many. With regard to the first 3 assignments of error, mother's basically arguing that, first the argument was the second motion for permanent custody which was filed June 12, 2018, specifically does say the child is not abandoned or orphaned, has not been in the temporary custody of one or more public service, children's service agencies for 12 or more months, which is why I did not argue an argument with regard to the timing. The motion clearly says that the agency was not proceeding on 12/22. The motion does say on page 52A of the record, all 5 children have been adjudicated dependent on 3 occasions, and then goes through with each of the 5 children, noting the case numbers and reflecting that each has 3 prior adjudications. So that's clearly spelled out in the motion for permanent custody, and while it does not reflect the specific statute section 2151.414B1E, the language clearly tracks the statute and sufficiently put mother and father on notice that the agency was seeking permanent custody on the first prong for that matter. So even though the trial court did make that finding of 12/22, the findings in that prong of the statute are in the alternative, and as long as one of those findings is valid, the other finding would be just harmless error, would not have any impact on whether or not the first prong of the permanent custody test was met. With regard to the argument regarding the retroactive application of 2151.414B1E, the agency would argue that for 3 of the children it was not retroactively applied. For the final child, even if the argument was that it was retroactively applied, the courts have held that 2151.414 is procedural and remedial in nature, and that it's therefore applicable to children subject to temporary custody at that time that the statutes become effective. And that was Emory Howard from the 9th District. So counsel is correct that there is a substantial right involved here, which is custody of the children. However, this statutory change did not affect the parent's fundamental liberty interest. It just affected the method and procedure by which the courts could determine whether or not parental rights should be terminated. So in light of that, and the fact that this constitutional issue was not challenged in the trial court below with the raising of a constitutional challenge, the agency would argue that permanent custody in this case was properly awarded. The trial court correctly found that under the first prong that permanent custody was applicable under 2151.414B1E, and that it is in the child's best interest, and that trial counsel is not ineffective for failing to challenge the fact that the case plan does not appear to have been adopted by the court, but was nonetheless discussed in many court hearings and amended many times. Thank you.
Thank you.
Thank you, Your Honor. May it please the court. Your Honor, for the third assignment of error, the retroactivity, we are not claiming the statute is unconstitutional. I think that's kind of a red herring. It is a perfectly lawful statute. We're saying it was applied in an improper manner. We're saying the judge applied adjudications prior to the enactment of the date in her decision. Again, that wasn't raised at trial because, again, nobody knew that this was an issue. When you look at the state's brief, or the state's motion for permanent custody, Your Honor, on page 3, it lists right here, read 1 under the should not, cannot, and they cite 2151.414B1A. That's it. Then they go into the D grounds. D1A is listed, D1B, D1C, D1D, and D1E, which is fine. Then they list what are the E grounds, because under a should not, cannot, you have to prove E grounds. And here the agency lists in its complaint, we think E1 has been met, E2, E4, E10, E13, E16. So under their own motion, they're saying here are the statutes that we plan on going forward at permanent custody. Now that they're saying, well, when we talked about the history of the case, we talked about how the children had 3 priors and here are their case numbers, the parents should have been aware that even though we're not claiming permanent custody under that statute, it was implicitly applicable. But again, that wasn't they didn't raise it in opening arguments, closing arguments, during the custody hearing. This was not an issue. So again, nobody knew that 3 priors was a ground that they're seeking permanent custody or the 12 to 22. So on that basis, Your Honor, I'd ask the court to look at all the records and reverse the finding of permanent custody in this matter. Thank you.
All right, thank you. Thank you both for presentations. Court will take the matter under advisement.